So let's talk about corporations. By the way, afternoon, it's 12:30 or 1 p.m. You will receive my note, my post regarding the midterm exam 2 details. Same number of questions, multiple choice, true or false. It's going to be in 102 as we have midterm exam 1. It's going to be Tuesday next week. Okay. And remember, Thursday, we have no classes. Not in person, not online. So this should be for Thursday. All right, so chapter 11. Well, we're going to talk about corporations now. And I just told you that sole proprietorship is a business on the individual, on the person. Partnership, the same thing. It's a business on the individuals, the partners. It's personal, unlimited liability. Now, corporation is different. Corporation is a separate entity. It's a separate person, but it's not a person as a human being. No, it's a legal person. It's a person created by the law. Because it's a separate person, well, there are many advantages and there are many characteristics we need to consider. Because it's separate, so it means it's separate from the people who own it. So when I say I own a company, technically speaking, I should say I own the shares of a company. Because a company cannot be owned. We own shares. Can we form a company with only one shareholder? What do you think? Yes. So a company can be formed by only one shareholder. Why would you form a company only as yourself as a shareholder instead of being a sole proprietor? Why? Exactly. Because you want to separate your personal assets, your personal savings from your business. Because as a sole proprietor, your personal savings are at risk. As a shareholder, all you can lose is the amount you have invested. Right? Unless you committed fraud and other things, then they can come after you. But if that is not the case, yes, you start a corporation because you are limiting your liability. Okay? Now, if you are the owner, and that's why owner is between quotation, because we, technically speaking, we don't own the company. We own shares of a company. And shares will give us the rights of that company. Rights and obligations too. Now, the shareholders or the shareholder, the only one, they do not own the assets of the business. It is the business, it is that separate legal entity that owns its own assets. Does it make sense? Now, if Steve Jobs had Apple as a sole proprietorship, when Steve Jobs passed away, the business would be gone. The business named Apple. But because Steve Jobs was one of the shareholders, whatever happens to the shareholders generally will not affect the company, the separate entity. Now, the shares from Steve Jobs, they went to the Steve Jobs heirs. Some of them were donated to charity. I don't know what happened to them, but the company was still functioning normally, right? Because the company is the separate legal entity. We say it's a legal fiction. It's a legal creation. It's a person, but not a human being. It's a legal person. So that things are separate. Now, the corporation, the separate legal entity, is vicariously liable for the conduct of employees, not the shareholders, right? Because shareholders have their liability limited. Limited to what? Limited to the extent they have invested. So let's say I have purchased shares from Apple. Or let's say I have purchased shares from Samsung. And when Samsung was ordered to pay $500 million to Apple, as a shareholder, it affects the value of my shares, but it does not affect my personal assets because the $500 million is payable by the company, by the corporation Samsung, not by the shareholders. Okay? Now, shareholders, they invest money in the corporation by buying shares. Does it make sense to you? And then it's the corporation, the separate legal entity, that will buy the assets and use the assets to make money. Shareholders, they own the shares, and the corporation owns the assets that it purchases. Separate. Now, it's this person created by law. It's not a human being, a corporation. If it's not a human being, their activities will be carried out by agents. So anyone who acts on behalf of a corporation could be directors, could be CEOs, senior officers, could be managers, could be employees, everyone. They are agents. BCAT is this separate institution. This building is owned by BCAT as a separate institution. But the activities of BCAT, lectures, management, registration, those activities are carried out by people. People that are, most of them, if not all, are employees of BCATs, and they are also agents of BCAT because they are acting towards third parties. Now, some advantages of a corporation. Well, the main one is limited liability. Liability is limited. Right? Main one. Now, my question is, why would you start a corporation instead of a sole proprietorship? To limit liability. But it could be that your activity is not risky. Let's say you have an activity that is not risky. Let's say you resell goods that are not risky. I don't know what goods wouldn't be risky. I don't know. Let's say caps. You would have an online business of reselling caps. It's not risky. Not too much risky. So if you are a sole proprietor, it's fine. You can have insurance. But what if you have a business of gardening, for example? It could be risky. There could be a flying rock going to your client's window. It could be risky because of you could kill, let's say, valuable trees, or I don't know. So it depends on the type of business, right? You may want to limit your liability, but also you should remember that it's more costly to have a business. Now, main advantage, again, limited liability. Now, that limited liability can be lost when courts, they lift the corporate veil, could be lift or pierce, corporate veil. This is a metaphor. Why a metaphor? You know, when the bride and the groom, when the bride is getting married, the bride has a veil, right? The veil is to protect. So the metaphor here is that the limited liability protects the liability of shareholders. Lifting the corporate veil means losing the limited liability protection. When will courts do that? Well, courts will do that when shareholders or directors, they act fraudulently. There's a real case from Ontario. This former husband, and I say former because he got divorced, he had to pay support, to make support payments to their children. And the husband decided to make money only through a corporation. So the husband formed a corporation, and all the money he made was through the corporation. So he could not pay, or he could not make support payments through personal money. And he said he couldn't afford. So the court understood that he was using the corporation as a shield, as a protection, not to make the family support payments. So the court in that case decided to lift the corporate veil and allowed corporate money from the corporation to be used for support payments. That's an example, okay, in which the limited liability will be lost. But I'm not giving you all the details, but it was established in that case that the former husband intentionally protected his money through the corporation. That's why they lifted the corporate veil. Now, there may be some tax advantages. I'm not a tax specialist, so I won't talk about it. And now, with regards to succession and transferability, well, that's what I said. When Steve Jobs passed away, the company was still there. It didn't affect the company. It affected the value of the shares because Steve Jobs was important, etc. But the company, because it is separate from shareholders, continue to exist. So, and also shares can be transferred at will, can be donated, can be sold, because the assets you have, they are the shares. As a shareholder, you have the shares. And if the shares have any value, you can sell them. You can offer them as security. You can transfer, you can donate, you can do whatever you want, unless it is prohibited. Now, shareholders, they owe no duty to the corporation. No duty. I am a shareholder of Apple, and I like to use Samsung smartphones. It's fine. I owe no duty to Apple as a shareholder. This is different if I am a director or if I am a senior officer. It's different. But as a shareholder, I owe no duty. Okay? Companies that have only one shareholder, usually the shareholder is also a director, is also a manager, the main person. Then in this case, they owe a duty. But if you are only a shareholder, you owe no duty to the corporation. Now, some disadvantages. But position of minority shareholder is weak. As I told you before, if I have, let's say if I have 3% shares of Apple, if I had 3%, I would be millionaire or billionaire. Even owning 3% of Apple, I wouldn't have a say because I would be a minority shareholder. This is different from a partnership. Remember that in partnership, for some major decisions, unanimous agreement is required. So it's a disadvantage here. And the disadvantage is that free transferability of shares may be restricted. The preemptive rights, we'll see this again later on, but this means that in most, not all, but most small companies, shareholders, they cannot sell their shares freely to others. They usually have to offer their shares first to the other current shareholders. If the other current shareholders say, no, we're not interested, then they can sell to others. This is when shareholders, they want to keep some control of who will be the shareholders for the corporation. This is known as the preemptive right. And it's the most expensive way to operate because it's more complex. You may need lawyers for directors' resolutions, for documents, file documents, etc. Now, process of incorporation. You can read this for your information, but you don't need to focus on this for exam. This will not be in your exam. When we talk about process of incorporation, what you should have in mind is that a company is this separate legal entity. If it's a separate legal entity, it has to be formed, it has to be created, it has to be incorporated. And how do we incorporate a business? Well, there are different ways to incorporate a business, depending on the province or depending if it's federal. So you incorporate through different documents. You can read for your interest, but I won't be focusing on that. This is more procedural in nature. I just want to call your attention for one specific concept here. In Canada, we have provincial or territorial companies, corporations, and we also have federal corporations. Now, when you start your own corporation, when you incorporate a company, you have to decide whether you want it to be like in BC, provincially incorporated or federally incorporated. Now, if you have a place of business only in BC, let's say you are a coffee shop, you can incorporate either one, provincially or federally. Usually, shareholders, they will choose provincially because some provinces, they offer some benefits for you to be a provincially incorporated company. There may be tax benefits, there may be subsidies, etc. But again, if you have a place of business only in BC, you can choose either one. But if you have a place of business in different provinces, you could go federal, then you would be able to do business all over. Or if you are provincial, in each other province or territory that you have a place of business, you would need to have an extra registration. So to avoid this extra registration, you could go federal. Okay, but there's no, you could do any or other. Just depends on what you believe is easier or better to you. Not only that, if you are a provincial corporation, you can become federal if you want. You go through a process. And if you are a federal and you want to be provincial, you can also do that. Again, you go through a process depending on the province. Those things you don't need to focus for exam. I'm just mentioning to you because we're going through corporation. Now, some other bodies that will be incorporated too. A city will be incorporated. A university will be incorporated. Incorporated, I mean, they are formed. They are the separate legal person, even though they are not for business. Now, capacity, we discussed this in chapter 7. Well, usually corporations, they have full capacity as an adult. Unless the law that created that crown corporation limits the capacity. Or unless the shareholders, the directors, limit the capacity. So by this, I mean, let's say the three of us, we are shareholders of a corporation. And we decide in our internal corporate documents that loan agreements over $50,000 requires the signature of majority, 2 out of the 3. This is an example of limiting the capacity, because in principle, the corporation could get a loan for any amount with only the signature of a CEO. But because we as shareholders, we are agreeing to that, that agreement needs to be complied with. And this is related to capacity of the corporation. Okay? The capacity could be limited to do business with foreign companies or with the government. So, but if it's not limited, we'll have full capacity. Now, how are corporations funded? Well, corporations will be funded 2 different ways. 2 different ways. One is equity. Equity, I mean shares. I give money and I get shares in exchange. I become a shareholder. This is one way. Another way, I am a creditor. I lend money. When I lend money, I don't become a shareholder. I am only a creditor. I will get my loan back, my payment back. So those are 2 different transactions. When I buy shares, I become a shareholder. Hopefully the corporation is successful and my shares give me return, but I have no guarantee of return. As a creditor, I expect my loan to be repaid, but I am not a shareholder. So there are different ways of funding shares, of funding companies. So when shares are exchanged by money, shares could be par value or no par value. Par value means that the share has a determined price on it. No par value is when the market determines the value of the share. So if you want to know, I have some corporations here in my phone. So if we look at some public companies, let's look at Amazon. Amazon share is currently, it's being traded now by $182.19. The market is determining the value of Amazon share today. So it means that Amazon shares, they are no par value. Their price is determined by the market. Par value is when you issue the shares, you say, oh, share is valued at $1 or 1 cent or 2 cents. This is not so common. It's still permitted in BC, but it's not so common. Most corporations that are formed, they are formed with no par value shares. And then as they grow successfully, the market will determine how much they are worth. Now, shares can be common shares, can be preferred shares. Well, this is only for academic purposes. And why do I say that? Because according to my practice, lawyers, they can mix up. They can make preferred shares look like common shares and vice versa. And the law allows that. But for us, let's keep in mind that common shares are the shares that give the right to vote. So if you have the right to vote, it means you have the right to set the direction of the corporation, where the corporation will go. Preferred shareholders, they usually don't have the right to vote, but they have a preference to receive dividends. When the company declares a dividend, the preferred shareholders have a preference to receive that. And if there's any money left, then the common shareholders may get the dividends. But the preferred shareholders, they usually don't vote. And if they don't vote, they do not set the direction, the strategy of the corporation. So this is when a company is funded by shares. Now, company may be funded by borrowing money. As I said, this creditors-debtors relationship. Well, this will be when there's a loan to the company, but there's two financial instruments here we need to know: debentures and bonds. Debentures is when the company wants to borrow money from multiple creditors. So they issue debentures, this financial instrument, and it's like a promissory note. It's like, okay, give me some money now and I will repay you in some years from now with a certain interest rate. But it's just a promise. There's no assets to secure. If they don't pay, if they don't repay, if they don't repurchase that, you just lose your money. So it's an investment. It's a risk investment. Now, a bond is similar. However, in a bond, there's an asset that secures the bond. If the company doesn't repay, doesn't buy back the bondholders, they can go after the asset. Could be machinery, could be real estate, could be intellectual property, anything else. So the difference here is that the debenture is a bit riskier than a bond because the debenture has no asset to secure it. I'm not a financial planner, not an investment advisor, but there's a principle in the financial industry that says the riskier the investment, the higher the return could be. Could be, because there's never a guarantee. So if you're seeking for a higher return, you would go for debentures, but it's riskier. If you want a more not so high return, but you want more security to your investments, you could go for bonds. Okay, so that's the main difference there. Now, difference between closely held and broadly held corporations. Closely held are small corporations. They have few shareholders and the shares are not sold openly. Most companies in Canada, in most countries, they are closely held. Very few companies are broadly held because broadly held corporations are the ones that have public share offering. Their shares are available in the stock market. Do you know any Canadian public company? Canadian companies that have their shares available to be traded in the Toronto Stock Exchange? Chalice? Maybe, I don't know, maybe. You can Google Chalice. I know most banks are. Most banks, if not all. I know Dollarama. Dollarama is an open, broadly held corporation. Okay, so, and because their shares are offered to the public in the stock market, they are more regulated. They have to comply to more legal obligations than the closely held corporations. All right, so directors, just wanna, this is for more medium to large corporations. We have the shareholders. The common shareholders, they have a right to elect directors. Okay, so director 1, director 2, etc., usually in odd numbers. And then the directors, they will appoint the senior officers, CEO, CFO, all the Cs. The senior officers, they will hire managers who will hire employees. So this is for more medium to large corporations. Shareholders, they own shares. And every year they have a meeting in which they elect directors. Directors are the ones managing the corporation. But they don't manage the corporation on a daily basis. The ones managing the corporation on a daily basis will be the senior officers, CEO, CFO, CMO, all the Cs that exist. And they will hire managers, managers will hire employees. This is for more medium and large corporations. Small corporations, if I start my own corporation, I am the only shareholder. So I will be the shareholder, I will be the director, I will be the CEO, I will be the manager, I will be the driver, I will be everything. Right? But for medium, larger corporations, you have this distinction here. So this distinction says that directors, they are elected by the common shareholders, the ones that have a right to vote. And the directors, they owe a duty to the company. So if I am a director of Samsung, I cannot be a director of Apple too, because I would be in conflict of interest. I would be breaching my duty. Directors, they have a fiduciary duty to the corporation. Remember, shareholders, they don't. Now, directors, they may be personally liable if they don't pay tax, if they don't pay wages and salaries. They are responsible for these. And then they will appoint the senior managers. Senior managers, they also owe a duty, a fiduciary duty to the corporation. It's correct here, appoint, double P, point. So they also owe a duty to the corporation, and they are held to a higher standard because they are the ones in the daily operations of the company. They are the ones with access to insider information, everything. So their standard is higher with regards to the company. So shareholders, we already know, they have a right to vote. They have no duty to the corporation. They have a right to records, financial records of the company. The preemptive rights again. So the preemptive rights, as I told you before, they entitle the shareholders to be offered new shares first. So we formed a corporation. We are 3 shareholders. Now I want to sell my shares. If we have a preemptive right in our corporation, I have to offer my shares to the other shareholders first. If they say no, we're not interested, then I can offer to someone else. The preemptive rights are also known as the right of first refusal. So you would have the right of first refusal. Now, shareholders, the minority shareholders, they have some protections. The main one is the derivative action or representative action. So this is when directors of the corporations, they cause loss to the corporation. And as a minority shareholder, I can sue on behalf of the corporation. So I'm a shareholder, again, here, we're a company. Directors of the corporation caused loss to our corporation, and directors didn't go for recovery of that loss. Let's say we sold goods to a client, and the client didn't pay. And the directors or senior managers, they decided not to sue that client to collect the money. So as a shareholder, I can sue the client. I sue under my name, but on behalf of the corporation, because it affects my rights. So that's the derivative action. There are other protections, but this is the most important one, the derivative action. Dividends. Do we have a right to dividends? No. Dividends are not a right. There are investors that focus their investments on dividends, but dividends are not a right. How do you know that? If you want to be paid dividends every 6 months, every 1 year, what should you do? You should look at the history of the company. If the company has a history of paying dividends, such as banks, Coca-Cola, GE, other big corporations, they pay dividends every year. Then you would expect to be paid dividends, but it's not a right. And why do those companies pay dividends? Well, first of all, because they are in profit. Companies that are in loss, they cannot pay dividends, they are in loss. But even if companies are in profits, they are not required to pay dividends. What if they want to use that money to make further investments, to pay more their employees, to build a new manufacturing plant, etc.? So whether companies will pay dividends or not is a decision from directors. Directors decide whether dividends will be paid at a certain year or not. Okay? Question for you. Simple one. Okay, we talked about fiduciary duty. Who does the agent owe a fiduciary duty to? Who is the person they are working for? How do we call the person agents work for? Principal. So the agent owes a fiduciary duty to the principal, not to the third party. Officer. Who does the officer owe a fiduciary duty to? They are the senior officers are the CEOs, the C's of the corporation, but who do they owe fiduciary duty to? To the corporation, not shareholders, to the corporation. They work in the best benefit of the corporation. Shareholders, they will elect directors, and directors will appoint the officers. Officers have to manage the corporation for the best benefit of the corporation, not the shareholders. Yes, they are creating value to the shareholders, but they don't owe a duty to shareholders. They owe a duty to the corporation. Directors, does a director owe a fiduciary duty to the corporation or to the shareholders? To the corporation too. Shareholders, do they owe any duty? They don't owe any duty whatsoever. So the right answer is directors, are in a fiduciary relationship with the corporation. We are shareholders of the corporation. We elect one director, second director, a third director. You directors, you owe a duty to the corporation, not to ourselves. If we don't like the way you act as a director, our remedy is to not re-elect you next year. But the duty is not owed to us as a shareholders, it is owed to the corporation. Okay, that's an important one. So as I said, this corporate structure is more for medium to larger corporations. Because shareholders, they are only shareholders, they will elect directors. Directors will form a board of directors. They are responsible for the management of the corporation. And then delegate this responsibility, or they appoint officers that will manage the corporation on a daily basis. Okay, so for medium to large corporations, we have this corporate structure. You see, those complexities, they are not present in a sole proprietorship. They are not present in a partnership. Partnership, there may be some other complexities depending on how detailed the partnership agreement is, but it depends on the partners. Well, corporations, they have to be terminated if you don't want the corporation to be alive anymore. Let's say the business is not good, you have to dissolve the corporation. You incorporate it and you dissolve it. So you file documents and you dissolve it, or you sell it. There are ways to resolve. So the main characteristic here is that the corporation is this separate legal person. The corporation is separate from the people, separate from the shareholders. And based on this separation, all the other details go. Activities are carried out by agents, limited liability, the duty owed by directors, senior officers, etc. Questions? Comments?